Supreme Court is the ultimate voice of authority for the entire judicial stream. Now, if the Supreme Court is not alert and alive to its responsibility to ensuring that the justice systems are not denigrated beyond boundaries, those below us are likely to suffer much more than we. And I can say that this is not a recent trend. The issuing of contempt summons has always been a tool that has been used by courts to ensure that the dignity of the court is not scandalized. If you will go through the history of our systems, you will find many examples. And so I think that my simple answer would be that the court is one out of 400 courts. The court is the ultimate voice. And whenever the court acts, whether it's the High Court, the Court of Appeal, or the Supreme Court, acts using the tool of contempt is to ensure that the justice sector is not scandalized beyond boundaries.
Mr. Chair, a quick
Lord,
follow-up.
No, let me just get... My Lord, you've been a lawyer for over 35 years. Am I right?
Yes.
In this 35-year period, if you recall, how many such contempt relating to a comment on the Supreme Court have you heard of, or can you remember, if any?
I'd like to remember a case from the High Court, not just one case. That's where the High Court is consistent. I'd like to remember the incident of the 2013 election petition when some political activists even were convicted. Some of them were not convicted because they came and purged themselves of contempt. Somebody was convicted. And yes, it goes on all the time. I remember an incident around 2008. And sometimes summons are issued, but the public doesn't hear because the persons run very quickly to purge themselves of contempt.
But in your 35 years with the Supreme Court, you can't count more than 5, can you?
I would say not, and that is good, because that we shouldn't have a lot of such situations.
But in your 35 years with the Supreme Court, you can't count more than 5, can you?
I would say not, and that is good, because that we shouldn't have a lot of such situations.
Well, it's because you use the word consistent. That's why I wanted to be sure. Maybe some had gone, I can count about 3 or 4. Consistency then eluded.
I'm grateful.
Yeah. So, Mr. Chair, the follow-up was that don't you consider the practice as a fetter on the right to freedom of expression?
The tool of contempt proceeding, holding for contempt of the court, is an age-old tool. It is one of the tools the court has been given to ensure that the peace and stability of the nation is not jeopardized. And so I would be very careful to have a problem with any of the tools that the courts have been given to administer justice.
Do you think we should have a Contempt Act?
Sorry, you're done. Very well. You're done.
Chairman, yeah. I just want to find out from the nominee. Just a follow-up. Assuming a citizen comments on a particular ruling from the Supreme Court and uses
Very often within the legal rhetoric, we use the expression sound and unsound. And so I would not.
Yes. Honorable Beerman.
Thank you very much. Thank you very much, Mr. Speaker. Your Ladyship, congratulations.
Thank you very much.
I see that for your CV, you've tried to explain better your background. Of course, everybody is trying to claim you. Cape Coast, Winneba, Gomoa, Alon, Wesley Girls, Achimota. Congrats that everybody is proud of you.
I'm grateful.
Of course, women of Ghana. Yesterday, my good friend Ace Anan Ankoma did a fantastic piece. There's a special feature. Has company law sculpted Justice Gertrude Torkornoo for Ghana? I don't know whether you've seen it.
I have.
You have. Indeed, in his piece, he made reference to the famous case of Bernard Sam versus Registrar of Companies, the 2014 case. And if I may be permitted to quote, as to quote you, you said, "It is my humble evaluation that this is a case which typifies the horrors of delays in our justice system. The appeal record is all of 24 pages. So why has it taken this appeal so long to reach judgment? The inordinate delay of 2 years between the High Court judgment and the placing of the case before the Court of Appeal for judgment is indeed worrisome and calls for reforms in the sluggish mode in which appeal records are prepared, ratified, served, and made ready for judgment." That was in 2014. My question is, what reforms have been made and do you intend to initiate to confront, as you said, the sluggish mode in which appeal records are prepared, ratified, served, and made ready for judgment?
There have been several reforms. As we speak now, we have 3 centers for production of appeal records, 3 central points. Every registry, of course, is has a duty to produce appeal records. Every process in the judicial delivery system is guided by law, is guided by rules, and is guided by fundamental rules such as the natural justice rules. And therefore, in creating any reforms, one has to be mindful of the fact that every party has to receive notice. Every party has to be heard. And these are some of the reasons for the horrific delays that sometimes we encounter. What I would do, or what I intend to do, in consultation with all my stakeholders, is to invest in practice directions, practice manuals, standard operating manuals or practices that registrars and other court staff have to comply with within time. Of course, always hedged by law. I think that sometimes we leave too much to parties because the process belongs to parties. But we have to compel parties also to move their cases along. Otherwise, we get the brunt of the criticism.
Thank you. My second question is about the status of the e-justice system. To quote Ace, he says, "It is hoped that if or when confirmed, Justice Torkornoo's undoubtedly redoubtable judicial favor and expressed frustrations with the judicial or the justice delivery system combined will lead to the much-needed root and stem reforms that scale up the current e-justice system to completely digitize and digitalize the court experience, deploying technology to further reimagine and transform our civil and criminal justice system. So as I started, what is the status of the e-justice system?
The e-justice system is a shift of the manual way in which we have done business for the last 100 and more years into the digital realm, which means that it comprises e-filing, e-service, e-hearings, e-case management, e-administration, and eventually should have e-auctions. Now, that's a national system. So we've had a lot of breaks when we have weaknesses in the national fabric. For instance, you cannot order e-service totally when everybody doesn't have an email address. So everything we do, we have to ensure that we are moving in tandem with the national system. It's good to see the Honorable Minister for Communication and Digitalization here. And I'm sure she sometimes gets a bit tired of all the different messages that I send to her on different issues. At every turn, it's an infrastructural machinery, and that in that infrastructure, everything must be properly situated and covered by law, and must have verification, validation, authentication. Everything must be in place. So it's not a simple situation. We are doing it step by step. And indeed, we've taken a long time in one location because we want to make sure that when we move it, we don't carry along mistakes.
Before you, let me ask this follow-up question. From what you have discussed, probably the entire value chain, the legal delivery system, have that been factored in a legal training?
Yes, we have consistent training. In fact, change management is a big thing. And that we have to train clerks, interpreters, registrars, registry staff, judges. And you know, this is a community in which there's a lot of technophobia. So you have to deal with the technophobia. You have to, you have to deal with getting people interested in using the machines. And then the stakeholders, the citizens.
My interest was at the schools, the faculties and the law school have their training taking into account the e-system.
We are developing curriculum for that, to introduce, because really every aspect of law now has to look at the e-angle. Contracts are virtually done online now, banking, financing. So the law schools really ought to be incorporating e-thinking.
Thank you, Your Ladyship. Of course, the last question will be on the common normal issue as to entry into the law school, and not only entry, leaving the law school. Indeed, for some of us who finished the law school in the 90s, we just more or less entered the law school. And after the 4 years, we left. But it appears that the young people that you meet, they tell you it's a nightmare to be able to enter the law school. Of course, Ghana has grown. We've become far bigger than what Ghana was. There are more schools training people to be lawyers. The other aspect is when they enter, after going through all this hell to enter, it takes them another hell to leave. And as I said, for us, we were during our time, you couldn't, people would be called to the bar in October, a few will be referred. April, they get a mini call, and that's the end of it. But you ever hear people talking about having been referred for so many times, and indeed, you only pray that they're able to leave within the shortest time. What would you think you can bring on board to help address this problem, not completely eradicate this situation, because it depends on other things apart from your administration? What would you think we should do to be able to make progress in this situation, in this regard?
I think, I'm sure when you went to law school, you were a full-time student and you were quite young. That was my situation, straight from sixth form. And we just studied. Now, many people in the law school are working. And I think that affects their ability to really engage with the law and pass the exams. If you recall, in the last 6 months, at least 1,000 people have been called to the bar. The last major call had 860 or so people being called to the bar. We had a mini call a few weeks ago, more than almost 200 people. I mean, a mini call having 200 people, that's unprecedented. So they are coming out and they are going in. But I think that the journey is a struggle for working people.
Yes. Arabayaga.
Thank you very much. Thank you very much, Chairman. Your Ladyship, Justice Gertrude Araba Esaaba Sackey.
Esaaba.
Esaaba. Don't worry, I'm a Kusasi man, so from Sirim. So the minority side of this committee actually had reservations about participating in your vetting this morning because you participated in the decision involving Honorable James Quayson. You asked that his name be struck off the records of members of parliament. But as a member of the panel and as a court, you did not give a reasoned judgment. So as we speak, we don't know the basis on which the court arrived at that conclusion. And there's uncertainty among us as members of parliament, knowing that our Supreme Court is also our constitutional court that should guide us as a country in terms of how we run public affairs. We would have thought that on a matter in which we were so divided in terms of the two political parties, a matter that was litigated from the very day in which this parliament was sworn in, the night of the swearing in of this parliament, till the 17th of May when you gave your ruling. It's a very divisive matter. We thought you would have carried all of us along by giving a reasoned judgment. Because when you give the judgment and you don't give the reasons, in between, people fill it with propaganda, speculation, and that just divides the country. It doesn't help us to move along together as one people. So we wanted the reasoning in that judgment to be able to really evaluate you, in addition to all the things that you have given us. But we've reached a negotiated position with our colleagues in which we've been assured that we will not vote on you today after this hearing, and that when we finish today, when the Supreme Court gives the reasoning, we will have another opportunity to now assess you on the basis of the quality of the reasoning of the court, and then we can take a decision. On that basis, I have no question for you today. I would wait for that day when we have the opportunity, and I will focus my questions on the reasoning that you will give in that matter.
I have an answer for your no question.
Yes, please.
Honorable Member, can I have an answer for your no question?
I will give you the permission. Please proceed.
And my answer is that I have given hundreds of judgments from High Court till now. And I think that it would have been a really great relief to know that I am assessed on my work as a whole. And then two, the judgments of the Supreme Court. You know, the Supreme Court is not a court unless 5 people are sitting. And in constitutional matters, we are 7. So 7 people are working together. And that's why very often, indeed, almost invariably, every judgment given by the Supreme Court comes out, the reasons come out long after the orders and the rulings, because that's how we work. Everybody has to check the jots and the tittles before you get the final script.
Yes. I thought you said you're not asking very much. If you want to ask a question,
Mr. Chairman,
you have 3 opportunities.
Thank you very much, Mr. Chairman.
No, wait. He has 3 questions. You commented that you may not ask further questions. But if you want to ask further questions, I'll give you the opportunity.
No, I'm not asking a question. She gave a response to my comment that I would reserve my questions.
No,
and
she
so,
responded to the issue as to why there is no reasons on the day they pronounced the judgment. That's the response she gave.
She was hoping that I would take a decision based on all the decisions that she has already handed, both as
If you want
High
to
Court
ask,
and
please go ahead and ask your question.
No, I'm just saying that this specific decision for me is the most influential. That's why I want to focus on it.
Very well. Yes.
Thank you very much, Mr. Chair. Justice Gertrude Esaaba, Sackey, Torkornoo, I congratulate you on your nomination.
Thank you.
The name is actually Torkornoo, not Torkornoo.
Torkornoo. Of course, I'm also from Dagbong, so sometimes you have to understand that the phonetics would vary. Thank you very much for the correction. So, my lady, when you were at the commercial court, I was then in the law school, and your court was more like, if you like, the Mecca for some of the law students. It was a place that we used to go to add to our knowledge of company law that was being taught by Mr. Setasanti.
Thank you.
I remember Justice Tanko as well. His court used to also be packed to the rafters. So we feel that you've made your mark. But
Thank you.
I have a few questions for you. First, let's go to page 12 of your CV on books and place. Books and Plays, Gertrude, Torkornoo, 2010. The Child and the Rainbow, Anthropology of Poetry, printed by Contempt Impressions. Can you tell us something about that book? I like children a lot, so I think that maybe it has to do with children. Maybe I'll learn a thing or two.
There's hardly anything about children in it. I think the child in the title refers to myself, and I wrote it at a time when I was not a child. But that collection really dealt with my Christian experience. So it was a collection of poetry that had come out of me during my times of Bible study and just thinking about Christian doctrine and having Christian experiences. And that's why that particular collection is called The Child in the Rainbow.
Thank you very much. My Lord, the Supreme Court gave a decision, and I'm making reference to the matter that my colleague, Honorable Ayariga, just referred to. The panel was made up of Justice Jones Doche as presiding judge, Nene Amegache, Justice Justice Mariam Owusu, Justice Gertrude Torkornoo, Justice Professor Henrietta Mensah Bunsu, Justice Emmanuel Yoni Kolendi, and Justice Baba Akayensu. It was a unanimous decision. You said that you filed a judgment at the court's registry on the 7th of June. Essentially, what the court did was to declare unconstitutional the election of Honorable Jeche, and that his election more or less violates and contaminates the Constitution under Article 94(2). Now, the court made reference, you cited a number of your previous decisions, including the matter involving Senator Rawlings, which, settles the matter. Oh, please, take it easy. Allow me. You said you won't ask questions, so let me ask the question for you. Please. You said...
Order,
me.
please.
I'll ask the question for you. I'll ask the question for you. My lady, the matter in reference has to do with the decision of the Supreme Court, not decision of Justice Torkornoo. How do you view the position that it appears that the decision is being imposed on one person? You are not even the presiding judge to start with. And secondly, assuming without admitting that you are the one writing the judgment. I'm not saying you are the one writing the judgment. Is it the decision of the justice writing the judgment? Are you the one who volunteers, or is the presiding judge who nominates somebody to write the judgment? Thank you very much, my Lord.
My Lord, you can ignore the first part of the question. Just the second part that you may answer.
Well, because this is a public hearing, I thought that I should answer, I should inquire about how he seems to have seen the ruling judgment, because I haven't seen it. I know, you see, the way our court works, we sit in conference. We sit in conference over every decision, every matter before us. As I said, it's not a court unless there are 5 people or 7 people. And so all these people will sit in conference. Everybody will present their position, their evaluation. We will agree the orders, the conclusion. We will craft the orders and the rulings. We will share it. Everybody will approve. And then it will be written. Sometimes, I have actually been on a panel in which different judges wrote different parts of the judgment. It was a very interesting experience. Sometimes one person will write it. Sometimes more than two people will write it. And in this particular situation, we had concluded on our orders and rulings, and we gave that to the public. And the judgment is currently a work in progress.
Thank you very much, my lady, for the clarification on this matter. In other words, it is not one person's decision, it's the court's decision. My lady, when you appeared before this committee in 2019, I was then selling petrol. I was then working at National Petroleum Authority, so I was not here. Now I'm here. One of the questions that was asked of you had to do with your demeanor on the bench. Some said you were confrontational, uncompromising, you were fastidious, you were meticulous, and so on and so forth. But I have, like I said, seen you in action. And I see that you are very, very meticulous. I believe that we are vetting you today not as a justice of the Supreme Court, as the chief administrator, head of the judiciary, has to do with administration. And I believe your meticulousness would come to bear because you can't afford to make mistakes. And so those observations that had previously been made, I believe, were adequately answered, would now come to stand instead of you and then make your administration, I believe, a very, memorable one. What would you want to be remembered with long after you have left the bench? Long after you have served as Chief Justice of the Republic of Ghana? At least for the next 10 years.
An increase in efficiency. And if as a lawyer, you would have noticed that the rules of court have laced within them timelines. And so I would be focusing very much on what strategic interventions. Indeed, the current strategic plan of the Judicial Service has that as one of the first action lines. What interventions to ensure that we adhere to the timelines that the law anticipates in the delivery of our work. I would also want to be remembered for incorporating technology effectively. I'd want to be remembered for an increase in capacity building, raising the capacity of the entire judicial service so high that we are known for excellence, among other things.
Thank you very much. I wish you well, my lady.
You're done. Yes, Vera.
Thank you. Thank you, Mr. Chairman. And, good morning, Honorable Nominee, Your Ladyship.
Good morning.
I want to take you to page 2 of your CV. I just found something very curious there. And in January 1969 to June 1973, Ejumako Local Government Primary School and Ejumako Methodist Middle School, and you have into brackets class 2 to middle school form 1. And you have another bracket that says, I escaped class 5. Would you want to share with this committee what those circumstances were? Thank you.
I know your committee is meticulous. You calculate the years and the dates. And I knew that if you calculated this, you would find that the class levels I was supposed to have been in would be short of 1 year. So I needed to explain to you that I didn't go to class 5. I was jumped. I was under the authority of my parents and my teachers, and that's what they thought I should do.
Thank you. Thank you for that explanation. My second question has to do with, of course, looking at what would you say will be the 5 topmost qualities that a Chief Justice must have, and whether you embody those qualities. Not in any particular order, you can just share them with us. Thank you.
I think a very deep knowledge of the law, because our institution is one that must be a standard bearer and must be a protector of the rule of law. So the Chief Justice must have a very deep knowledge of the law and the philosophies of the law and how they operate nitty-gritty. The Chief Justice must be a person with emotional intelligence, able to deal with all the people. I think a Chief Justice must also be progressive in thinking, because you are managing a resource for the country, the administration of justice. A Chief Justice, I've given you 3, and you want 5. I think a Chief Justice must have that sense of responsibility to the entire country, because the weakest person needs justice. And so you must have that sense of responsibility and compassion. And last, the Chief Justice should be able to network with every community, because our work is done in communities.
Thank you, Your Ladyship. I think my final question would rest on maybe one of the ingredients I expected you to mention, which is personal integrity, because it's become very important in the scheme of things in this country for now. One of my colleagues earlier asked you about the perception that the Supreme Court is become an appendage of the executive. And I think you tried to give us some responses to that effect. I will want to go back on that and just want to find out from you that we have citizens who live online. We call them netizens. And they come up with all sorts of opinions and views about everything that happens within our judicial system. Would you say that you'll be able, would you be able to tell this committee how we got here as a nation, where all of us have become suspicious of the Supreme Court?
Not all of us.
And allow me to ask my question. Allow me to ask my question. Where all of us have become suspicious of a lot of the decisions and rulings that emanate from the Supreme Court, and what you will do to eradicate that negative perception, whether rightly or wrongly, and to give us a better face of the Supreme Court. Thank you.
Well, on the question of personal integrity, I thought that was an unquestioned, because I think that anyone who has interacted with me knows that I don't compromise on that. When it comes to the multiplicity of voices on the internet, on opinions about the courts and the Supreme Court, I think that an excellent answer or an excellent help tool will be to constantly put out the data on our work. So for instance, if at a material time we're dealing with the court, our court is dealing with 200 appeals, and none of them has to do with anybody in the political space. We're dealing with public interest actions, originating actions. I'm sorry, I have a 12 o'clock alarm. to help me know that the day is, yes, thank you. So the data will help us. Because honestly, the number of cases that involve persons in the political space are so few compared to the work we do. Perhaps the ordinary citizen doesn't talk too much about what they have in court. And maybe those in the political space talk a lot about what they have in court. And that's why that is there. And putting out the data, I guess, will help to give a sense of proportion.
Yes, Honorable Boama.
Thank you very much, Chairman, and congratulations, my lady.
Thank you.
My question one is taken from your answers you gave to this committee as far back as 2019. And the report of the committee on your answers to a question on judicial reforms in Ghana's business environment. You gave an elaborate answer on how our asset register was not properly used, difficulty in judges getting information from the company's registry, and so forth. The Companies Act, fortunately, came into being in 2019. Can you share with this committee some of the challenges you had with the previous act and how this new act has helped with the business environment or reforms that you spoke about when you appeared before us in 2019? Thank you.
I think that my answer, if I recall correctly, dealt a lot with properties. And the fact that executing judgments was a nightmare because you could hardly guarantee property ownership from the records from our land registry and other property registries. The Judicial Service is constantly engaging in different programs. And we have been through what we call the Business Enabling Environment Program. We are currently going through the Business Regulatory Regime initiatives, both of them with the Ministry of Trade. And in those programs, we are responsible for the enforcing contract segments. And what we do is design strategies to ensure that our work is made more efficient, and then engage other stakeholders whose work affects us. So when it comes to property registration, I recall that a few years ago, we requested that through local government, we should have access to the property rates registries, so that could help us verify home ownership during execution processes. So those are some of the initiatives. But I must say that it's in the trial court that a judge really comes face to face with the problems. And so now, and I have been out of the trial court for more than 10 years. So now as an administrator, I'm going to engage seriously again with the problems faced by trial judges, so that we can find solutions.
Chairman, my second question is that those around this table are politicians, and when it suits us, we make all sorts of promises to the public for obvious reasons. My lady, let me refer you to Chapter 8 of our Constitution. And the chairman doesn't want us to be asking questions that you are knowledgeable about, but this one is it's about the executive, and particularly Article 71(1)(b), 71(1)(b), for benefit of our listening public. Okay, 71(1)B. The salaries, the side note is determination of certain emoluments. The salaries and allowances payable and the facilities and privileges available to 1B, the Chief Justice and other justices of the Superior Court of Judicature. I looked at Article 290 and found that this chapter is an entrenched provision of our Constitution. And elaborate procedures have been set out for the amendment of those provisions. And this is what most people talk about as, or call the ex gratia. What is your view? Because previously you spoke about in support of some constitutional reforms and reviews by the Constitutional Review Commission. What is your take on this public debate on ex gratia? Thank you, which affects your office and the office of other justices of the Superior Court.
I think that consistently the Association of Magistrates and Judges have responded to the question of ex gratia for judges and made it very clear that judges don't receive ex gratia. We continue in office. We don't go anywhere until we retire. We don't have a cycle. And therefore, the discussion of ex gratia is not at all applicable to us. And this specific provision, where our names are mentioned, deals with how our salaries are set. And Article 71, as you know, there's a committee, a presidential committee that does that work. And the framers of the Constitution thought that that was the appropriate thing to keep us independent. And we are not the only persons subject to it. But you are right that this is an entrenched provision. And it can only be changed by very elaborate procedures.
Thank you, my lady. My last question is on your CV. Hobbies. Watching movies. Obviously, Kuma Wood. And I'm sure you like Kuma Wood. Reading, writing, and evangelism. Evangelism. What is evangelism and what do you do? Do you have time to go out to preach the word of God with this very difficult duty as a Justice of the Supreme Court and now the Chief Justice nominee? Thank you very much and congratulations.
Evangelism is informing anyone that salvation lies in no other person than the Lord Jesus Christ, and that all have sinned and fall short of the glory of God. Amen. And you ask whether I have time. I think that anyone expresses their core beliefs consistently in whatever they do and however they spend their time. I think a previous questioner asked me, the honorable member asked me about my book, The Child in the Rainbow. That's a writing that expresses my faith, and I do that all the time. And then I also lace it into my conversations. And I hope that anybody listening now will know that. John 3:16. That for God so loved the world, he gave his only begotten Son, that whosoever believes in him shall not perish, but have everlasting life. Thank you.
Hello, the comment at the table is that John 3:16 means something else to other people.
In fact, to us, John 3:16 or Napo. Napo.
Yes, Honorable Agaga.
There is only one source for John 3:16.
Your Ladyship. Your Ladyship, if you're given the nod, you'd be the head of the judicial arm of government, one of the three arms. Now, that arm of government has not been spared of criticism. And some of the criticisms can be described as perceptions or real. I'll just give you quite a number of them. First of all, the judiciary has been accused of bias, especially when it is handling political cases, so to speak. In fact, some have argued that in recent times, the Supreme Court has developed the appetite to hand down unanimous verdicts when it is handling political cases. The judiciary has also been accused of delayed justice delivery. Delayed justice delivery. And unfortunately, corruption. Your Ladyship, if you are given the nod, what steps would you take to erase some of those perceptions, particularly the one that borders on bias when the court is seized with the so-called political cases? Now, this matter gained prominence when our Minister for National Security spoke in a sensitization workshop when the National Security Strategy was launched. And these were the words of the Minister for National Security. He said, "Injustice," and I'm quoting him, "occasioned as a result of the absence of an effective justice delivery system or delayed justice or biased justice is certainly a threat to national security. Indeed, when injustice abounds, particularly in situations where the bench, which is considered the final arbiter of disputes, is deemed biased, citizens tend to take the law into their own hands, and most times without recourse to the established systems of justice delivery," unquote. The source is My Joy Online, dated 8th April 2022. Honorable Obiamwa.
My Lord, please respond to the question.
He asked, his question is, I have captured two: bias from unanimous decisions and corruption. There was a second one.
Delayed justice.
Delayed, yes. All right. On the issue of unanimous decisions, I think that whenever you encounter a unanimous decision, it tells you that the law is totally on the side of the position taken by the court. That every member of the court, in fidelity to their judicial oath, cannot take a different position. It tells you that that is what the law is. So the only response is to learn from what the law says. So it's not a matter of bias. It's a matter of the legal position. Then, on the issue of corruption within the judiciary, I think that from my experience, I have come to understand how these perceptions abound. As I said, the judicial service has more than 7,000 employees. Only 400 or so are part of the judiciary. anyone who presents themselves as able to take money on behalf of a judge gives that perception. And very often, we as judges, including those of us with the reputation of being unbribable, find ourselves in that corner where people go out and present that they are going to give you money. And others believe it because they don't know it. So they don't know that you are unbribable. So there's a whole market, we call it judicial predators. There's a whole predatory group around our function. And that is something that we constantly try to address in our study of ethics, both for judges and for staff. So there are interventions, they just have to be deepened. And then for the community to understand, this is something I would really love to tell Ghanaians, that for every 10 people who tell you, give me money for a judge, you can be sure that 9 likely is going into that person's pocket and not to a judge. So please, don't give money to people to take to judges because it's their own market. It's unfortunate that that perception has prevailed because of the nature of our work. Our work is extremely technical. Sometimes people lose cases because they didn't abide with rules of court, they didn't abide with rules of evidence, they didn't abide with substantive law precepts, and so they lose the case and they don't understand. The law is difficult. That's why law school is difficult. And so when people lose cases, they tend to wonder why they lost. And then they come up with all sorts of notions. And so if you ask me, I would actively engage the community, as my predecessors have done. I'll heighten it, and I would speak very aggressively about being wary of those who present that they can give money to judges.
Your Ladyship, in response to an earlier question by the Honorable Zuera, you spoke about the qualities of a Chief Justice. Now, I'd like to know from you, I know ever since you got elevated to the Supreme Court bench, you participated in determining quite a number of cases which bordered on constitutional interpretation. Now, what is your judicial philosophy when it comes to constitutional interpretation?
I think that generally, when you look at the theories around judicial philosophy, I can describe myself as a textualist. I'm always interested in the context. Because I'm interested in the text, I'm interested in the context. And that's what I try to do in every work. What did the law say? And what is the current context? What are the facts of this particular matter? And so that's my answer.
Okay, so Your Ladyship, this is a follow-up question on the view.
Ask your question. If there's a need to give you another one, I'll give you, but you ask your question.
Very well, Honorable Speaker. So, if I understood you well, you're a textualist. So, what views would you then have on theories such as a living constitution, as espoused into an Attorney General, so that the Constitution, when you are interpreting it and the need arises, you must treat it as a living constitution because it evolves over time. What would be your view then, having stated categorically that you are a textualist? What would you do in a situation like that?
I would not be an activist in the sense of reading into how the Constitution ought to be interpreted just because society has evolved or changed or whatever. I will consistently ask what was in the mind of the framers of the Constitution, what are these particular facts, and I would read the Constitution as a whole. And then I would also look at all the supporting statutes and the regulations. You know, lawmakers, I have a very healthy respect for lawmakers. Lawmakers do a thoroughly good job. And so it's important to always take a deep dive into all the different arenas of legality around a particular question. And that's why I say I'm a textualist. I'll look at the text and the context before I come to a conclusion.
Last question. Oh, please. My lady, the career magistrate program, which was instituted some time ago, was meant to solve a specific problem at the time because not too many lawyers wanted to join the bench at that level. Now, I am reliably informed that some career magistrates have been cleared to do further studies. And as a result, quite a number have now been called to the bar. Your Ladyship, if you are given the nod, what do you intend to do with those career magistrates who have now become lawyers in terms of their elevation and what have you? Because originally they were employed as career magistrates. The idea was that they would stay there. But now they have become lawyers. How do you intend to deal with them, Your Ladyship?
As you know, the Chief Justice can never take a decision alone. So these decisions are taken with the Judicial Council. These decisions are taken with management. And so I would rather get the views of my community in the way forward. But the Judicial Service, as I said, is a human institution. So we had a certain position, the career magistrates came in. The understanding was that they appreciated that they would remain magistrates. But the humans, and they decided that they have aspirations. They want to study. And so there's been a review of the system. I guess there will have to be a constant review until we reach total equilibrium.
Yes, Honorable Minister for Communication.
Congratulations, Your Ladyship. I've known
you
you for over 30 years and admire not just your intellect, but your personality and the principles that guide you in your life and work.
Thank you.
And I've also worked closely with you on the e-justice project, which you chair and have oversight of. I know a lot has been done to use digital technology to improve the efficiency and output of the judicial service. However, challenges still persist. So what are some of those, and how will you work to resolve them?
I think a constant challenge will be how to move the system to what you and I call the last man. The last man is the person living in a village who hasn't got access to Wi-Fi, easily. And so we always have to design the manual side and ensure that the rules of operation can be engaged both digitally and manually without putting anybody at a disadvantage. And so that's a principal challenge. It's an ongoing process. And I think that even in advanced countries, you can hardly find a totally digitized system. And so the e-justice will have to constantly grow at that rate. And we may find that 40 years from now, maybe there are still people who are insisting on living manually. And we have to provide for their access to justice. So it's a process we have to work with.
Thank you. I give you our assurance that we stand ready to support you in this endeavor.
I'm grateful.
You've been involved in the practical administration of justice literally all your life, both as a practicing lawyer and a judge. And you've seen the evolution of this sector and the impact that some of the developments ongoing in the sector may have had on the quality of advocacy at the bar. What suggestions do you have to improve upon that, if indeed there are challenges with the quality of advocacy at the bar?
I think that continuing legal education is critical. It's legal education in subjects that are identified as a necessary source of learning or the need to increase capacity in at every material time. Many countries require that lawyers go through study in particular subjects throughout the year, a certain number of hours, etc. And I know that there's a brisk conversation going on about it, and that's something I'll engage the bar on. There's already a process, or there's already a program in place, and I'll engage the bar on actively about it. That is needed for increasing the quality of advocacy, because advocacy is not just the oral presentation, but even the quality of pleadings and the quality of appreciation of the rules of court. And if there's a bad lawyer, or there's bad lawyering, not bad lawyer, but bad lawyering, then you know that the poor citizen may lose a case when they didn't need to.
In 2012, Honorable Adamu Dramani Sakande, the then NPP MP for Bawku Central, was convicted by an Accra High Court after being found guilty of perjury and forgery. This decision was hailed by the NDC, leading to a by-election which brought Honorable Mahama Yariga to Parliament. I have no doubt.
Honorable, for the record, there was no by-election.
Okay. Which led to Honorable Mahama Ayariga coming to Parliament. I have no doubt.
That's also not true.
That despite the fact that
I was in Parliament before.
I have no doubt, as Member of Parliament for Bawku Central in 2012.
Can you proceed with the question and leave the individuals out, please?
Mr. Chairman, I have no doubt that despite the fact that losing parties and their supporters may not like the outcome of the cases, they utilize the mechanisms of the judicial system, including the review process, to see if they can overturn it. Or they learn to live with it, just like the MPP did in 2012. In view of your answer on the allegation of bias due to unanimous decisions being an indication that the decision confirms the legal position, would you advise our friends on the other side who seem unhappy at the James Kwachi case.
Honorable, can you reframe your question, please? She has no business advising any side. Please.
Would
if you want to
you-
ask a question on the law,
Okay.
please do.
Would you encourage all parties before the courts to use the legal processes to advance whatever position that they want, and or live with the decisions of the courts, whether they like it or not? Thank you.
The courts produce their rulings and their judgments. And beyond that, we have no other opinions.
Yes, Honorable Fuseja.
Congratulations, my lady.
Thank you.
My lady, the courts are choked. Litigation is expensive. And we all agree that it takes too long a time for litigants to get justice. What will you do in promoting alternative dispute resolution if you are given the nod as the Chief Justice?
I'm very grateful for that question. A lot of work has been done. I intend to increase the tempo of that work. As you know, we have CI 133 that was introduced in the as an amendment to CI 47 to allow for pretrial settlement of commercial matters, both at the Circuit Court and at the High Court. And so that means that in every commercial matter now, the litigants can engage with pretrial settlement. But as you know, mediation can be expensive because mediators have to be paid. Of course, they are not paid at commercial premium, but they have to be paid. At least there has to be a budget for it. And so I will engage all those involved in supporting ADR, because really it's the best gift to any disputing group. There's no appeal because the outcome is a contract. There's no appeal. So litigation ends very quickly, and you are not confined to the claims you brought to court. You can always negotiate a better deal for yourself. So I will work assiduously.
I am happy, and I'll be watching out when you are giving the nod to see how you help ADR progress.
Thank you very much for that promise. Because of you, I will work.
Thank you. My next will be to know your favorite Chief Justice or Justices, your reason for making them your favorite, and what you can do to improve what you like about them.
Kindly allow me not to choose a favorite. I have worked under 4 Chief Justices, and I have enjoyed working under all of them. Currently, I'm working under an acting Chief Justice, and I'm enjoying working under him. And so do allow me not to choose a favorite. And I have found that all our Chief Justices have been excellent people, those I have worked under.
But you can answer the next bit without mentioning names, what you like about things they did, and what you seek to do even more in respect of the things you
Honorable
like about them.
Elizabeth Tejari, she has answered. She has worked all of them. They are very good. So if you want her to tell you what more she can add, I think she has answered that question, even what legacy she wants to leave. So I'll suggest that you ask another question, please.
Well, I'll let it go. My
Thank
next
you.
will be your take on custodial punishment in respect of sentences that allow judges to either give a fine or a custodial sentence. Your take on that one, because we know that prisons are choked.
I agree with you. You know, penalties are designed to be reformatory. And so I think that if fines can solve the problem, then it's best not to send one more person into custody.
I wish you all the best.
Thank you very much.
Honorable Quarty.
Thank you very much, Mr. Chair. Your leadership, congratulations on your nominations.
Thank you, sir.
Mr. Chair, one of the challenges that the Regional Coordinating Council continuously is faced with as issues of delay in justice about land cases in courts. We know that the land tenure system in this country clearly does not encourage people, if you like, to wait for the processes to go through before even they commence work on their land. Currently, as we speak, there are so many land cases, land dispute cases in courts. One example that I can cite is just around Boteman that has taken 23 years in court. What do you think can be done in delivering justice in time so as to boost the confidence of the ordinary Ghanaian who want to go through due process in determining the legitimate owner of a land?
I think an increased use of technology. We've been looking at technology that allows the superimposition of plans very quickly and clearly when cases are commenced. And that's one area that I'll be extremely interested in moving along very quickly. Because a lot of the delay comes not from the fact of the conflict, but from deciding what exactly the issues are and how to resolve those issues. And then also, sometimes parties deliberately start a case in court and don't want it to end. And sometimes somebody gets an injunction and then he goes to sleep. And because of the independence of the judiciary, it is not our remit to wake cases up when parties have not come to court. So we have to begin a new engagement with what are case management rules. If a plaintiff starts a case and is not following it up, how do we strike it off? If after certain conditions. So technology, case management rules again, and then training, increasing the capacity of judges and also lawyers on practical issues. I understand, I hear what you are saying on different levels, and I'm answering on different levels.
Thank you very much. Let me borrow some of the words you used in your earlier responses to questions that were posed by my colleagues. Responsibility, compassion, and network with the community. Now, like Honorable Obiamwa earlier said, I'm sure Honorable Obiamwa in the last 20 years may not have engaged in continuous education, but is a good lawyer. There is this issue going around about a decision that is likely to emerge from the quarters of the judiciary regarding continuous education of legal practitioners. What are your views on this matter? Legal education, sorry.
I recall that she spoke to that a couple of minutes ago. If there's any direction that you want to retake, but otherwise, she has responded on a question like that.
Mr. Speaker, Further and better particulars will not be bad at all.
Yes, my lord. But
Regulation is a part of professionalism, and I think that the conversations around regulating our profession are appropriate. If the Judicial Council, the General Legal Council, the Board of Legal Education want certain interventions to increase professionalism, it is useful that the stakeholders give their feedback, and then everybody arrives at a good position that will be complied with. That would be my answer.
Thank you very much. Mr. Speaker, my final question will be the verse that she eloquently quoted. How would you balance your position as a devout Christian, evangelism and the practice and the legal practice? Well, that's what you put it, if I should quote what you said earlier. So with your belief and a Chief Justice, somebody commits a crime, how do you balance the two?
I can assure you there's no conflict. There's no conflict. The law is the law, and Christian doctrine is Christian doctrine. And where they merge, that's fine. Where they don't merge, my work in the law is in the law.
The Speaker, a follow-up. So in church, you will believe what the Bible says, and then in courts, you believe what the law says.
Absolutely, because in church, I'm required to be true to whatever circumstance I'm in. That's what integrity is. In court, I'm to abide by the law.
Thank you very much, Mr. Speaker.
any more from here?
Thank you very much, Mr. Chairman. Mr. Chairman, my first question has to do with the issue of JUSAC. The staff of JUSAC, as reported, have expressed issues about intimidation and coercion anytime they want to express their unhappiness about the work environment. In 2019, for example, the leadership of JUSAC were almost sacked when they embarked on a strike. Just yesterday, the workers of the Judicial Service of Ghana were virtually forced to open the courtrooms for the Supreme Court to sit. These acts of intimidation and coercion are against the ILO Convention number 87. Only recently, the Judicial Service Workers Association expressed their happiness about the environment created by your predecessor, Justice Enemiabua, and they commended him for maintaining a friendly work environment. What assurances will you give the Judicial Service Association of Ghana on issues about intimidation and coercion, especially on their leadership, as far as their job security is concerned, when they express their unhappiness about the work environment?
I think that I said earlier that I've been in meetings with them, even though I'm not in office yet. I was co-opted to sit in, and we had very cordial meetings regarding the current situation. But apart from that, I think what happened regarding the opening of doors had nothing to do with their strike, because the court doors are not, the court doors are under the administration of management. And so long as citizens were standing outside, it was important to attend to the citizens. And I believe that those issues have been ironed out.
Madam, recently, Supreme Court judges occupying official bungalows were evacuated and the bungalows demolished in the name of a national cathedral. How much, what is the accommodation situation of these affected judges, and how much has it cost the judicial service so far to provide alternative accommodation for these judges?
To the best of my information, every judge who needs to be accommodated is accommodated.
My question is not fully answered.
She said, has it cost you anything more? Or how much has it cost you, if you know, that to accommodate the judges who were relocated?
Because I haven't been part of management in that capacity, I do not know about values.
Madam, my next one is on, you made mention of technology. Cybercrime today is one of the most complex issues in jurisprudence. Issues about the dangers AI is bringing, issues about deepfake, and other such technological advancements have made issues about gathering evidence and facts very, very technical and difficult. In your estimation, how prepared as a country are we towards addressing these issues, not to make it difficult for the judiciary to be able to dispense justice and fairness?
I think that generally we are doing well as a country, seeing that we don't have so much in resources. There may have been some incidents regarding bank accounts, etc. But if you notice, we regularly receive alerts when there are problems. That is my perception as a citizen. When it comes to e-justice, I agree with you. Ensuring the integrity of documentation and the security of personal records within the justice sector and the security of the system is a huge part of the cost. It's a huge part of the cost, and it's a necessary part of the cost. You cannot take your eyes off it. So every step we take, we have to ensure that investment is made in the integrity of records and the protection of records. And that's why we are moving slowly. It's one of the reasons why we seem to be moving slowly.
Yes, Honorable Dr. Moore.
Thank you, Chairman. Madam, congratulations.
Thank you, sir.
Chairman, my first question or concern has got something to do with minors. I mean, those in US, the definition is under 18, but when it comes to alcohol, tobacco, and other antisocial behaviors, it's under 21. To be honest, these variables are independent variables of insecurity with very high degree of integration in our society today. I've been going through the law books. I'm not a lawyer, so forgive me. I haven't seen any specific law that controls the involvement and participation of these antisocial behaviors when it comes to these factors. If there is, let me know. If it's not, I don't know if you consider that in your jurisdiction to do something about it, because it's really, really, really being dysfunctional to the performance of our republic. It's costing us economically. So I want to find out if there is a law that really strictly deals with this situation or not. If not, what will you do? If it is, are we really enforcing it? That's my first question. Thank you, Chairman.
We have very robust systems for. Are you listening, sir? We have very robust system for managing administration of justice around children. The Juvenile Act. We have special courts for children, special rules for children, and we are very particular about them. We have good systems. But on a national scale, if I'm hearing you right, I think identity, ensuring that people show their identity when they are buying alcohol, they show that they really are qualified to engage in particular transactions. That is outside our hands. Or what I mean by our is the judiciary. That's a matter of, I think the administration of that is totally outside of our remit. But what is within our remit, we are very robust about it.
Thank you, Mr. Chairman. And that has helped me a lot because I've learned. It moves me to the next question, which is almost the same. It's something about power of separation. The Constitution, Article 2, talks about supremacy of our Constitution. And the 93.2 emphasized the fact that the provisions invest power in Parliament when it comes to dealing with the legislative power. But sometimes, I'm not a lawyer, I come across situations where we have a clash. Just recently, there was issue about, cannabis hymns.
Cannabis, yes.
The other aspect, which is not legal, because I haven't read it anyway, is I don't know exactly what they define in Ghana, because in most jurisdictions where they even bar the use of Indian hymns, they also legalize industrial cannabis because it has a huge amount of economic value. There's so many countries. So even that law, I think we need to check and see which one we mean. And secondly, I want to find out between...
Let me try and deal with what you first said. Okay. I don't want the question to get too burdened. I think that you are referring to the constitutional duty or one of the jurisdictions of the Supreme Court, which is to ensure that any enactment or any act that is done in violation of the Constitution is not allowed to stand. And that is a function that we engage in all the time.
Are you done?
I'm waiting for his attention. That is a function that we engage in all the time. When public interest, when cases are presented to court, we do the evaluation, whether they can stand the constitutional standards, and then a ruling or a judgment is given. As to the rest of your question, I think that I'm not qualified to answer it.
Chairman, thank you. The last one. Madam, this issue about freedom of speech and fundamental human rights, earlier one of my colleagues made mention of that controversial issue. I think a lot of people in our country today are abusing the fact that there's freedom of speech, so they can say anything at all. Sometimes a layman like me, just as I'm sure I'm committing some mistakes here legally, in terms of legal knowledge, I get confused that I can say anything at all. It doesn't matter how it tarnishes one's reputation in the name of freedom of speech. So where can we have clearly defined lines, or if there should be any explanation, so that we know where it starts and where it ends, and the other one starts and ends? Because I think it's giving rise to much controversy in our society. I want to find out. Thank you, Mr. Chairman.
I think we have enough laws around the subject. We have the laws from the law of tort, T-O-R-T. Then we have, in defamation, defamation laws. We have enough legal regimes around speech. It's about enforcement. It's about enforcement and people, and I think that it's critical to appreciate that society is dynamic. People the society is growing. We are exposed to different things, and so certain cultures will creep in. And so all of us have to be mature, and all of us have to assist and use the regulatory frameworks to ensure that we don't destroy the fabric of our society and that we build the fabric of our society. Everybody has a responsibility. When it comes to us, we will discharge our responsibility.
Yes, Gisela.
Thank you very much, Mr. Chairman. Live pure.
Speak true.
To it, it's the motto of Wesley Girls High School. And she's an old girl, and she's my senior. Although I didn't meet her in Wesley Girls anyway, much younger. Your Ladyship, on your CV, it says that sorry, congratulations, by the way.
Thank you very much.
On your CV, it says that you volunteered for 6 years with legal aid. Can you tell us the status of legal aid in Ghana today, and how decentralized are the services, and what you would do as Chief Justice and as somebody who has volunteered in that space before to make it accessible and more democratic to all? Thank you.
Thank you. I volunteered with FIDA, the International Federation of Women Lawyers, and I know that we need a lot more resources, so much more. The Legal Aid Board is functional. It's a very busy board, but we need resources as a country. We need to lock hands together, ensure that the most vulnerable people have access. Sometimes the qualification, the criteria that qualifies you to access legal aid itself can put some people outside of it. And then sometimes people do not even know that it's a resource that's available. So more officers needed, more officers needed, more communication needed, and more resources made available.
Thank you. I believe
But it's something I certainly will not let slide under my watch.
That's good to know. Thank you. What signal do you think is being sent to Ghanaians in the diaspora on dual citizenship, and the signals that is being sent with all the courts brouhaha going on around Honorable Kweson's case? What signal do you think is being sent? And what do you think you would do about it if you become Chief Justice to give comfort to the diasporan community?
You know, under Article 8 in the Constitution, we started out without even allowing dual citizenship. We have evolved. That article has been amended, and we have made several steps towards embracing Ghanaians who take on other citizenship. So I think that in terms of regulation, we are doing well. People have to read what has been put down.
So if we are doing well, then how does that stand with the Kweson's case?
When the reasons come out, you will read it.
Mr. Chairman, that means that I think, as you stated at the beginning, our vetting may be incomplete. Well, Madam, Your Ladyship, sorry, what is your view on judgment debts? And on whose part is the failure?
my personal view is that it's a big problem. It's a big problem because I think there are many cases that are not well defended. I think we need to look at the issue of how we apply interest rates closely. I think we need to look at how contracts are managed in the public space closely. Very often, the transactions are in one ministry and have to be defended by the Attorney General's department. And I have come the relevant ministry is not giving enough information to the Attorney General's department for them to defend the matter. So I think it's a section of justice delivery that, as a country, we have to make ourselves alert to, and everybody with responsibility should pay attention to. I will do my part.
Thank you very much. On that note, I wish you well, and hope that as the Chief Justice, if approved, your era of leadership will be different, will be innovative. You will speak true and right the wrongs, and have impactful interventions that I believe you know, with all your experience in the judiciary, you know are very necessary to be able to deliver justice in the system. Thank you very much.
Thank you very much, Honorable Member. All your words have been taken to heart.
Honorable Suhini.
Thank you, Chairman. Honorable Nominee. Mr. Chairman, let me, before I begin my questions, raise an issue that relates to maybe Parliament and our data systems and how they are kept. In my research for this exercise, I was shocked to realize that even though the nominee appeared before this committee only a couple of years ago, 3 years to be precise, 2019 November, this House has no record, verbatim report of her appearance. According to the people in charge.
Honorable Member, I think this has nothing to do with her.
That's why I said it has nothing to do with her.
We will deal with it in the back room.
I said it has nothing to do with her,
So
but I
please,
just think that it is
let's
important
leave.
that...
Kindly, let's please, I beg you. Let's go back.
Mr. Chairman,
If, please, can I regulate it?
Yes.
What shortcomings there are in our administration is internal to Parliament. There are procedures for dealing with those ones. Now, we are doing the public. Please, you can make a statement outside of here, exposing how weak our systems are. But please, let's continue with the consideration of the nominee, please.
I appreciate that, Mr. Chairman, but you see, this is a public hearing, and the people out there hold us to higher standards, and they expect that if a nominee appeared here and said certain things, they will want us to know. And I'm saying that it's a big challenge that we have to resolve. We should not be, shy about it. We should fix the problem internally. So that it has to do with the committee, because I first went to the committee office. This is where I started looking for the information. Mr. Chairman.
Go to the question. I want us to avoid argument over this. Please go ahead.
I just don't want us not to have a record of this next year. Let's take note of this. And let's not think that I am washing our dirty linen in public. I think that it is important that we fix our problems internally, because it helps improve the job that we do here. That's the point I just wanted to make. Thank you, Mr. Chairman. Now, I take note of the nominee's inclusion of Sackey into her names, and she has said that she will submit the Gazette to update our record. And I particularly was excited about her reason for the inclusion. As a father of daughters, I am really excited about the reason for the inclusion of Sackey. But it also gives me an indication of how strongly you are tied or related to family. And I would have ignored it, but I read somewhere about you being the niece of Major Sam Akwa, a very popular military officer who was the managing director of GIHOC, who unfortunately was murdered, under very bizarre circumstances in this country. You would have been about 20 years around that time, judging from your age. How did you have any relationship with him as a niece? How do you remember it? And has that impacted your choices in life in any way?
He was my mother's first cousin. I was in the university at the time. And yes, I remember the incident very vividly. I don't think it has impacted my choices in life. That's what I think that's the answer I can give.
All right. Let me move on now to, as a deputy ranking of the Lands and Forestry Commission, I am concerned about the use of state lands. Lands and Forestry Committee. Did I say commission? Leader, thank you for drawing my attention. I meant committee. I can't be ranking of a commission, so you should know I was referring to committee. I'm concerned about lands, especially the use of state lands. You will recall that about 12 appeal court judges and their families had to be relocated into rented apartments, costing at the time, we're told, not less than $2,500 a month, with a promise to build them 21 ultra-modern replacement apartments in 18 months, when a decision was taken to put up a national cathedral at where these 12 appeal court judges and their families were living. In fact, at the time, the information is that there were even some bungalows that were still under construction. The bungalows they were living in were less than, in some cases, 5 years old. I have also noticed recently that there's judicial service lands around the cantonments area, near the Namibian High Commissioner's residence, where some, judges were housed, around Elwak. I've noticed that it has been taken up by private developers recently. Now, my question is, what will be your, and maybe related to this also are reports of the decay that we see at the recently constructed Supreme Court building. That's just less than 5 years old. The court complex, the court complex. What will be your attitude towards the preservation of these lands or assets or properties belonging to the judiciary? And do you know if those 21 ultra-modern apartments that were promised when the 12 judges were relocated have been delivered? Thank you.
Yes, they have been delivered. I actually live in one of them. And my attitude to protecting the assets of the judiciary will be robust.
What does robust mean? I'm sure the viewers out there are also asking, what does robust mean? Madam.
Robust means that as an administrator, I'll be absolutely interested in knowing where all our properties are. I'll be interested in knowing what is happening with them, the state of them, and ensuring that they are well protected, because we need them.
My Lord, can I ask this question? Does Judicial Service own any property, or they are properties of the state allocated for the use of the judiciary?
I believe that these are properties of the state allocated to the judiciary. But if they are located to the judiciary, then the judiciary must be in control of them.
I understand that carefully, but I'm worried about creating the impression that it's the judiciary's property. It's the state property. The state may reallocate to somebody else.
I think that if the state is to reallocate them, it can only do that with our consent and our information. No, I don't think that the state, because we are part of the state.
Exactly the point I was seeking to make, because, I mean, this definition of what the state is, I know, will take us into another realm of argument. But I hope that the chairman is not suggesting that the state refers to the executive.
Please,
that
just
can,
go ahead with your question.
That can offer land and take it at will and relocate it to anybody that they want. I hope that's not what the chairman is suggesting.
If we get an opportunity, we will argue that between you and I, and I'll show how. Because if I allocated it to you, I can't take it back. That is legal. Please proceed with your question.
Well, it looks like this debate has nothing to do with you, Honorable Nominee, but I'm on your side on this, and I'm hoping that you will actually ensure that land or properties allocated to the judiciary are protected and used to the benefit of all of us, and the executive should not encroach on it at will. Now to my next question. It has to do with career magistrates. It was something that many people in that area hailed. They were happy when it was introduced. At a point, a number of them were even given study leave to go upgrade themselves. And their promise was that they will be converted to become professional magistrates. As we speak, the concern I get is that many of them have not been converted, even though they have undergone their training and returned. They have not been converted to professional magistrates. Some have been converted, but there's no criteria, there's no standard that ensures that it is monitored and it is based on merit. What will you do about that, assuming, without saying, that this House approves you to become the Chief Justice? What will you do about the fate of these magistrates who do not know when they will be converted to professional magistrates, and even how they will be converted?
I know the House will approve me, thank you. But beyond that, I think that all of these situations are covered by documentation. They're covered by records. And it's important to work with the records, the undertakings given, the actions undertaken, and how the stage at which whatever change has occurred is in. So I will work with the records. There cannot be conversations that anybody makes presumptions about. The records must speak to the situation.
My final question. I see that you are a person of faith. Membership with AGLO and all. And let me share a quote by Harold J. Berman in The Interaction of Law and Religion, where he writes, quote, "Unless people believe in the law, unless they attach a universal and ultimate meaning to it, unless they see it and judge it in terms of a transcendent truth, nothing will happen. The law will not work. It will be dead," unquote. Honorable nominee, I've seen you, or I've heard you quote Bible verses, including Hebrew 11:1. Hebrew 11:1.
You don't know Hebrew?
Quote, quote, "Faith is evidence of things not seen," unquote. I've come across you make reference to that. Faith is the evidence of things not seen. That is believing something that cannot be seen or proven with tangible evidence. And I'm struggling to contextualize that within the profession that you find yourself in, where we are told that evidence is everything. Can you educate me?
I can understand where you are coming from. It's a favorite line I use when I am teaching on certain vision, mission, and goals, which is one of the subjects I teach, which is that we always start with something that is innate, our creativity, and then it's expressed outside. So that's what faith being evidence of things not seen means. There's something inside of us that comes out. But in the context of law, law is textual, and our duty is to interpret, construe it, apply it. That's why I said earlier that when I'm in court, I have my legal head on. When I'm at home, I have my faith head on. But I never lose my Christianity in both arenas.
So there's no case where...
Thank you very much.
Where...
Yes, Honorable John Kuma.
Hey, chairman.
Thank you very much.
Mr. Chair, just a quick follow-up, just for the records. Honorable Sohini.
Honorable Markin, may I give you a quote from Lord Denning? Being a lawyer, I'm sure you know of Lord Denning, one of the greatest...
just want to...
no, I want to give him a quote.
Oh, to him?
Yes.
Okay, before. Okay, he says he can't take the quote. So it's fine.
If I'm allowed, then we can engage. Mr. Chairman, if I'm allowed, we can continue to engage. But if I've been ruled out, then she cannot no longer be making references to me.
She answered your questions. You wanted to follow up. But you had asked 4 questions instead of 3 that has allowed everybody. You wanted a 5th option, which I declined. That's right. But you...
Honorable Markin, if you don't mind, I'll give the quote to you before you go on. All experiences convince me not only that God is ever present, but also that it is by contact with the Spirit of God that the spirit of man reaches its highest and its best. This is a quotation from the Right Honorable Lord Denning in his book called The Closing Chapter.
Yeah, Mr. Chair, it's in connection with a quote from my respected colleague, Sohini. I mean, I think it was not complete. If you say faith is the evidence of things not seen and substance of things hoped for. I think that's a complete thing I just wanted to put.
Thank you.
Yes, Honorable John Kuma, please.
Thank you very much, Mr. Chairman. I want to specially congratulate Her Ladyship, Justice Gertrude Araba, Esaaba, Sackey, Torkornoo.
Thank you.
And I also want to use the occasion to pay special tribute to the outgoing 14th Chief Justice.
Is that intended to be a question for the new?
Yes, it will finally end into a question.
I'll be closely
Justice
monitoring.
Kwesi Eniniebua.
Closely monitoring.
Yes, please monitor. My question is on legacy. My observation of Chief Justice Kwesi Eniebua's period as Chief Justice was his focus on expansion of infrastructure and new facilities for the judiciary. And I highly commend him for that. I know you as one of the boldest voices in the judiciary currently, and I'm impressed anytime I read and hear your independent views on matters before the Supreme Court. A lot of people are looking up to you, especially our young girls. What, in your personal estimation, do you want to be remembered for as your legacy? Taking over, oh, maybe I'm late, but okay.
Yeah, unfortunately, you are late.
Maybe I'm late on that.
He has answered that
Yeah,
question.
okay, so.
Let me ask another one.
Okay, so the next question that I want to ask will be, there is constant call on constitutional review in the country. And many of the concerns that, especially non-lawyers who have called for constitutional review in Ghana have said that the president is too powerful in the 1992 Constitution. Of course, as a lawyer who has seen so many clawback clauses in the Constitution, I don't agree with that position. But because I'm also a politician, maybe people think politicians have different assessment of issues. Please, what's your independent assessment of the role and power of the president in the 1992 Constitution? Will you call for an amendment of the 92 Constitution because the president is too powerful? Thank you.
I really would not want to share any views on that subject, except in relation to the judiciary. I noticed that in Article 146, the process for removing a judge starts with a petition to the president. I do think that the work of the judiciary should not be cloistered in the hands, the origination of anything regarding the judiciary should not be cloistered in the hands of the president, so that if you have a president who does not want to remove a particular judge, and yet that judge's work is inimical. So far, we haven't had any crisis, but I'm just thinking ahead. It's only in that context that I think that we need to open up some of these provisions so that individual institutions can also have a say in some of the issues that affect them in that context. But that's about the only thought I have.
Mr. Chairman, just a follow-up on that one.
That's your second question. Go ahead.
Okay, thank you, Mr. Chairman. Your Ladyship, many people have described that function of the president as only an accelerator. He is not even expected to have an opinion of that assessment. Do you agree with those who think that it's only a procedural role of the president receiving the petition and forwarding it? Do you agree with that position?
Absolutely, I agree with it. But if he doesn't forward it, what can we do?
Thank you, and I wish you well.
All right, I'll give you two. Reverend Ntumfojo, I'll give you two. Two, please.
Thank you very much, Honorable Chair, for your magnanimity. Your Ladyship, Araba Esaaba Sackey Torkornoo JSC. Congratulations on your nominee, on your nomination.
Thank you very much.
I was enjoying, and I've been enjoying your submissions, your preaching, your eloquent quotations of relevant portions of the Holy Book. And I couldn't stop admiring that in your position as a lawyer, as a legal professional, and also a member of the upper echelon of the judiciary, your personal Christian views are publicly always upheld, and that I admire. In your earlier submissions to the committee, your leadership, you made reference to judicial predators and indicated that in most cases where the activities of judicial predators had been encountered, it is very likely that 9 out of 10 of proceeds from the activities of judicial predators may end up with the judicial predators, and only 1 may end up with judges. But do you agree that that may indicate 10% prevalence rate of the canker? Are you concerned about that 10%? And what steps would you take when your nomination is confirmed as Chief Justice of the Republic to address that supposedly or potential 10% prevalence and to address the activities of judicial predators? Thank you.
Yes, I'm concerned about the 10% because we ought not to have any such situation. You know, a judge is supposed to be, constitutionally, under the Constitution, you must be a person of good moral character and proven integrity, and so there should not even be any whisper. That said and done, I think I've mentioned that judicial ethics is a subject that is consistently raised within our judicial training. Every aspect of our judicial training, we address the question of ethics. We work on it. We work exercises, we talk about it, we have orientation on it, and we address it. I think also that you say corruption, as you know, is an activity that occurs away from everybody's eyes. And that is why perhaps the predators have a field day, because who is to know what is going on? And so, to my mind, ensuring an active consideration by the citizenry that you ought not to be giving money to anybody, because justice is your constitutional right, is maybe one of the most potent forms of addressing the matter. But beyond that, I think that there would be sanctions available to address any errant behavior. And for me, it is about always ensuring that whatever activities we undertake in judicial administration are regulated by law. You cannot tamper with anybody's rights outside of propriety and legality.
Thank you very much. Your Ladyship, you also indicated further that you believe that the practice of justice is done in communities. And in that respect, I suppose that you believe also strongly that the wheels of justice ought to be running and running smoothly in every community, most communities, and equitably. Considering the current deficits of circuit courts and high courts equitably across the length and breadth of this country, what steps will you take to ensure that deficit is further addressed, considering that your predecessor did significant efforts on that recently? He commissioned a circuit court in my constituency together with me, and that is the first circuit court all the way from Adanse, Obuasi to Yamransa before getting to Cape Coast, that long stretch. That is the very first circuit court. And I believe that, and many such courts were also commissioned, but there's still a bit more to be done. What will you do to address that deficit in that respect?
I think the studies that have supported the work that has been done under His Lordship and in Yeboah, the studies indicated 207 courts. They identified the need to build 207 courts. So far, what has been built is fewer than that. We've made a lot of progress, but we are yet to get to the 207. So I will meticulously pursue the construction of the rest and also ensure that anything that needs to be done to get them done is done.
Thank you very much, Your Ladyship. I wish you the very best. And lastly, as a Christian and a lawyer, having indicated to us just in a short while how you've managed these two, what will be your professional legal position and your faith position on the matter of LGBTQ and the position of the Law Institute?
I think I have made it clear that when I walk into court, all my thoughts are soaked in the law.
On the law.
Yeah, so the law we make, she will implement. She will apply it.
I wish you the very best, Your Ladyship.
Thank you.
Yeah. Now I'm at leadership. Honorable Chief Whip.
Thank you very much, Chairman, for the opportunity. Many of my questions will be public interest questions. I am not a lawyer, so forgive me if I don't come across as such. First of all, earlier, some colleagues asked you questions about, at least to us ordinary people, the question of contempt of court, especially the Supreme Court, is quite a nebulous one because I've read severe criticisms of, for instance, the Supreme Court judgments in the United States, where even speakers describe judgments in quite severe terms, and we don't see anything. But it's as if in Ghana, people are ordinary until they become Supreme Court judges, and they said, look, you can't say that about Supreme Court judges. What exactly
Honorable Member, that's not correct. So kindly take that out of your...
Which one is it?
That they are ordinary until they become Supreme Court judges. No. It's not what you think. It's not correct, please.
Mr. Speaker.
Honorable, let me guide you. What? Honorable Suhini, please.
Okay, let me say it this way. I see ordinary people I know as lawyers, and the day they become Supreme Court judges, it's as if they are completely different human beings that must be treated. I'm saying, that is my view. Why don't you allow me? Honorable Esla, even when you were saying things about Honorable Yariga, which were not factual, we allowed you to say
Proceed
them.
with your question, please.
Okay. Is it? Oh no, you said she came through a by-election, but that's. Chairman, is she actually the chairman currently? Then why don't you just allow me to make?
Can I have some order here? Honorable Minister, please. I haven't given you the floor. I shouldn't give you the. I haven't given you the floor. Okay. Please proceed.
Okay. Your Ladyship, is it the case that when the boundaries of what contempt is are not quite clear, people are allowed to say whatever they say, and then you say that maybe within what you understand, now you have gone beyond the boundary? My question is this. I can see that you are a scholar because you've written books and you've done certain things. Will you make a commitment to perhaps help codify what you call contempt and describe the boundaries so that in the case that somebody is making comment, the person will know that
You don't have to be a lawyer, but you know that this is the boundary. Would you help or give an assurance that there will be a way to codify what is contempt in this country? Because ever so often, Your Ladyship, we've seen, even colleagues, members of parliament, one person will say one strange thing about the judiciary, and in the eye of the public, he gets patted at the back of his hand, and then another one comes from the other side, and it's as if that person is treated completely differently. And I'm saying this, you know what I'm saying. I take the case, listen, I take the case of the Muntie 3, and then our own colleague, Honorable Kennedy Ejepong. And as an ordinary person in the country, I ask myself, what is the balance? Why is it difficult for the court to come up with at least similar judgment, so that we know the boundaries? So that is why I said that I'm not a lawyer. So if you answer this question, then you ask, you tell me whether it is necessary for us to codify what contempt is, so that ordinary people know the boundaries within which we protect the sanctity and the integrity of our courts and the practitioners for our own good. That's my first question.
Thank you. You know, the challenge of our work is that every case is fact-specific. So you have myriads and millions of different sets of facts. And then we have sets of legal principles. And our job is to apply the principles to the different sets of facts. Sometimes the law that's applicable is in statutes, sometimes is in common law principles, etc. Sometimes is in regulations, different arenas of law. That's the challenge of our work. That's the skill we apply. And therefore, I can understand why you may be confused about why this and why not that one. It may be the facts of the case. I'm not vouching for it, but it may be different facts. In asking why the Supreme Court responds, I think that I had earlier indicated that we are custodians of 400 courts, judges, hapless citizens who are doing their best. And we must ensure that the administration of justice is not denigrated in a manner that is not allowed by law. On the issue of whether the law on contempt can be codified, I think that's a very interesting request. I will look at it.
Thank you. My second question is about another public interest. Recently, there has been a ruling by the court, and on the 17th of July 2020, My Joy Online reported, and it was quoting our colleague, the Deputy Minister at the time of Justice, as saying that, for instance, birth certificates are not a proof of nationality. And this is a comment he made in relation to a ruling from the Supreme Court. When I take the form you fill to get a birth certificate, for instance, they call it a birth registration form, Form A. B, a portion called B, particulars of mother. Under that, 9, it states a national of. So the mother has to state whether he's a Ghanaian or she's a Ghanaian or not. And then when you come to C, under that, 16, also the father, you have to state the national of the father. When you come to the certificate that is issued to the person, it is quite clearly written the nationality of the person, because the person have ticked the two boxes. The mother or the father is a Ghanaian. Therefore, he or she qualified to be a Ghanaian. So if today, the ruling, according to our colleague, is that a birth certificate is just a mere record of birth, what then is a proof of nationality in this country. And I will be very happy because I see in front of me probably the most senior people in the judiciary in this country. And I think Ghanaians who are ordinary like me may want to know, if I hold my Ghanaian passport, is it a proof of my nationality? Is my birth certificate a proof of my nationality? So I want to understand the understanding of that ruling, why it is as if a birth certificate is not a proof of nationality. Meanwhile, on the form, you will have to certify clearly that you are a national before you are given a certificate as a national of this country.
Honorable Member, Honorable Chair, citizenship is a matter of law. Nationality is a matter of law. Certain jurisdictions, being born in that place makes you a citizen of that country. In our country, being born in Ghana doesn't make you a citizen of Ghana. It is your relationship with your mother, it is your mother's identity, your father's identity, it is your lineage that determines your citizenship. So, that form records, that form is actually an international requirement. We must know where everybody is born. That form assists to know your antecedents. But beyond that, your nationality is derived from the information on that form. It is not the evidence of your nationality. It is the beginning of appreciating how your nationality must be determined. It's an originating process.
So if I hold a birth certificate duly issued by a state institution in Ghana, Registrar of Births and Deaths, and it states nationality, Ghanaian, are you saying that that is not enough proof of the nationality of the bearer of that certificate?
May I answer you this way? If you had an English person come and live in Ghana and have a baby in Ghana, that person would have a birth certificate. But that person's record of the parents on that birth certificate would indicate that they are not Ghanaian. So the certificate is a record of where he was born. It is not an indication of the citizenship.
I've already said that in the generation of the certificate, I quoted on birth registration form, Form A, Part B, particulars of mother, because if your mother is a Ghanaian, a child from that mother can claim.
Honorable Member, from the birth certificate, if your mother is Ghanaian, if your father is Ghanaian, then we can conclude that you are Ghanaian. But from that certificate, if your mother is not Ghanaian, your father is not Ghanaian, that certificate is a record that you are not a Ghanaian. So it is a record that allows us to, I am doing legal deduction. I don't know how else to express myself.
So can I use a birth certificate issued by the births and deaths in this country that says I'm a Ghanaian? Can I use it to prove my nationality as a Ghanaian?
The birth certificate will never tell you that you are Ghanaian. The birth certificate records where you were born and the nationality of your parents.
So the information on that certificate that says that my mother is a Ghanaian, my father is a Ghanaian, would that be sufficient to prove my nationality as a Ghanaian?
Will be sufficient to arrive at the conclusion that you are Ghanaian. It's the beginning point.
Karen, your ladyship, can a Ghanaian passport holder use a Ghanaian passport as proof of being a Ghanaian?
I believe so. Because before you arrive at the passport, all your antecedents, such as a birth certificate, would have been evaluated?
By your, I'm saying it in a very respectful way. By your age, I don't know where my birth certificate is today. By your age, it is more likely that if you are asked to prove your nationality, you might produce your passport rather than birth certificate. Is that the case?
I have my birth certificate.
Okay, what Mrs. Speaker, once she offered that she's got it, can she produce it to be added? Oh yes, to be added to the document. Yes, Mr. Speaker. I did not ask for it. She volunteered it, so if she can add it to the document we are requesting.
Let's proceed with your further questions, please.
I have another question. Currently, we have the three arms of government we have. We have 275 members of parliament. Chances are that we come from almost every corner of this country to represent the good people of Ghana. In the appointment of ministers, the executive, the president takes that into account, and as much as possible, appoint people, ministers, and so from various parts of the country, because it's enjoined to do that as much as possible according to the Constitution. Public perception sometimes is such that there are sections of the public that believe when judges are appointed, especially judges of the higher courts, the spread of their locations from the country is not representative of the broad spectrum of the country. I'm just saying that it's a speculation. In the administration of justice, is it necessary to have justices coming from across the country? Because I know in Parliament we say that the police, the military, and everything should be a spread of the country so that even the way they do their work will be easier for them. In your view, do you think that in the appointment of judges, that spread should also be taken into account?
I think diversity always enriches every group. And so if any group has different ethnic backgrounds, gender backgrounds, faith backgrounds, it enriches the quality of thinking.
In your earlier answer to a question about Article 71, you rightly said that, indeed, the judiciary's salaries or remunerations are determined as it is for members of parliament. A committee is set up to review that after every 4 years. Indeed, you are probably paid something after the review, i.e., maybe you should have been paid 100 cedis per month, but you were paid 40 cedis. So when that commission carries out their work, they pay you something which is what you were supposed to have been paid at the beginning of the 4 years. But in your explanation, you said the public, that you don't take ex gratia. The difference is that you are still in your job. The member of parliament actually terminates at the 4 years. If he is lucky, he comes back. But indeed, you are also paid something at the end of the 4 years. Is that the case? You can call it a gratia, you can call it salary adjustment, but you are paid something. Is that not the case?
Everybody's salary is their legal right. So when you pay me less than what I'm supposed to earn, and later you tell me that this is what I should have earned, and you work out the difference and give to me, you're only giving me the balance of what I should have earned.
Oh, in that case, are you sympathizing with members of parliament and ministers of state, since they are all accused of taking something they are not entitled to?
Cannot speak for them.
I have, these ones are personal. Because of my profession, I noticed a news item recently that says that the court complex is in a serious disrepair. And indeed, when you go there, sometimes some of the floors and facilities are not fit for purpose. In fact, some of your courtrooms are on upper floors and your lifts don't work. I just wonder if a disabled person is seeking justice and the particular courtroom is on the 3rd or 4th floor. How are you able to provide justice to that individual if your lifts don't work?
That's an excellent question. But the comment you made earlier about the decay, etc., you need to remember that that building is right by the sea. And so it's experiencing the effects of the sea. So it's about renovation and repairing of the effects of the sea. And that's being done. We are taking steps in every direction. These things are a cycle, and we continue to do our best. Now, I said it's an excellent, the question about the disabled person is an excellent question, because if someone has to go up to the 5th floor for a case and the lifts are not working, that person is disadvantaged. So I think that the proper thing to do, and the thing that I really would hope the person would do, is to bring it to the attention of the law court manager, of the Chief Justice, of the Judicial Secretary, of the Registrar of the Court, anybody in leadership that they have access to, that this is my situation. And then the case can be transferred to a court that is more easily accessible. Because there's only one high court, and every high court, I mean, so long as the parameters of the case can be heard in a court closer to the person, that's the best thing to do. So it's just about giving information.
Okay. This House passed a law which is about disability. And that law allows the country to take steps within 10 years of the coming effect of that law to make sure that public buildings take steps to make them fit for purpose in terms of people living with disability. That 10 years passed maybe another 10 years ago. Don't you think instead of encouraging individuals to contact court officers and other things, we should rather try to enforce this against a particular state institution who has failed to implement fully the provisions of the Disability Act and serve as a deterrent to others to take the necessary steps? You may be surprised, even Parliament may be called upon to answer questions if we were to enforce that particular law.
If you recall, your question was about failing lifts, and that's the question I answered. It's not that the building is not accessible, but it may be on a floor that's not accessible because of a peculiar situation. That's what, and that's the answer I gave, that if there's a peculiar problem, it's important to respond to that situation. But so long as the building is accessible, I think that that building would have answered to the dictates of the law. I think every institution must comply with law.
I'm very grateful for that. And by the way, the breach of the law is not only on the upper floors. You could have a building on the ground floor, and the thresholds do not allow people with certain levels of disability to access that building. So I think the court should take a look at that and see if they can help the various authorities to implement the disability law. That will be very helpful to all of us.
My Lord,
Thank you.
My Lord, did the judiciary obtain building permit before constructing that court complex?
I will ask and get an answer.
Well, because I assume that before a permit is issued, all the legal professional issues relating to fit purpose would have been considered. So unless
Thank you for drawing my attention.
Thank you. Yes.
Speaker, I'm grateful for the opportunity. Let me quickly commend the nominee. Very impressive CV, and also to say that, Speaker, largely I am convinced, as she's dealt with the overarching issues that and observations that members have raised, except to ask a few questions. Honorable Nominee,
Thank you, sir.
what will you seek to do in your first 100 days in office?
Work very quickly on practice directions and manuals. That's very much on my mind.
Thank you, Mr. Chair. Concerns about land cases, Honorable Nominee, has come up, your ladyship has come up strongly in this country. And I heard your eloquent answer when you spoke to 3 factors: technology, case management, and I think lawyers, if I'm right. And as I listen to you, it appears to me that the matter is more complex than it appears to most of us. And for want of a better expression, it looks like a cul-de-sac. What, in your estimation, will be the way around this complexity?
See, reform is never a magic wand. It takes cooperation. It takes, very often we actually design programs, and you have to find the resources, you have to find the right facilitators, you have to do change management, you have to find tools and devices for ensuring that the reform is incorporated into the way we do business. And so it's a process. Getting anything done is a process. And I do not have any blinkers on that anything can be done so quickly just by promising, because I've worked in reforms for many, many years. And I've seen you have to think, start implementing. Sometimes you do user utilization records. You see that this is not moving as fast. You ask yourself, what other intervention? You set up subcommittees. It's a human process.
Your ladyship, we've all come to this conclusion that ADR is a good concept to help us in the dispense of justice. And over the years, we have implemented it largely. In your view, what are the shortfalls? And given the nod, what will you seek to do differently in our bid to apply the concept of ADR in the practice of our justice system?
I think increase communication on how effective it is. I don't think people appreciate that settling a case in ADR can take you out of the court